Hi, everybody. Welcome back. All right. Thanks so much. My name is Jennifer Valentino. I'm with the Wall Street Journal, and we are going to have a discussion here about my favorite surveillance technology. They're known colloquially as Stingrays, and I think most of you are here for Chris's technical explanation this morning, but he's going to go over a bit more about this particular type of device and how they were originally used and how they're used now.
So I've been interested in the Stingray for a couple of years now. There are two sort of things that really pushed me down this path. The first was reading DOJ's electronic surveillance manual, and there's a line in there that basically tells DOJ employees, if you're going to use one of these devices, if you're going to use a Stingray, make sure you call Mark Eckenweiler first. And for those of you who know, Mark, before he left DOJ, was like the godfather of wiretapping at DOJ, and so the fact that there was a line in there saying, don't use this without calling this guy, was like a big red flag. There was something suspicious about this technology. And then in the spring of 2011, I received an email from the court-appointed shadow counsel for Daniel David Rigmaiden, who said, hey, I've found you by Googling. I think you might be interested in some of the items in this case. And it turned out that there was an amazing case with a pro se defendant who was running circles around the government and had been able to somehow figure out that they'd used this high-tech surveillance device in his case. I gave that to Jen, and she ran a front-page story about it. And ever since then, there's been a lot of interest, both in the privacy scene and in the media, about this high-tech surveillance technology. I want to just talk a couple minutes about what I've learned in the last couple of years about this stuff. So the Stingray is the trade name for a generic device known as an IMSI catcher, IMSI catcher. And these have been around for about 15 to 20 years. They came out of Germany and the UK, and in fact, there was a long patent lawsuit between several German and British company over who owned the patent for this. And last year, or 2 years ago, the British Appeals Court ruled that actually this was not original enough to even be deserving of a patent. Originally, this technology was used in the intelligence and military space, and to a large extent, it still is used a lot there. Although Harris has really captured the US law enforcement market, the US military uses similar technology made by Boeing and Selexion, a British company. And in fact, there are lots of other governments around the world who are using this stuff too. We've known that law enforcement have been using technology like this for about 15 years. As I mentioned this morning, Kevin Mitnick was caught using one of these devices. As I understand it, the device was actually on loan from Bell South, who at the time was concerned about people cloning analog phones to make free calls. These devices have traditionally been very expensive, around $60,000 a pop, although Harris's latest product in the Stingray family costs $170,000. Local and state law enforcement agencies have been buying these in the last few years, largely through DHS grants, as I understand it. And so I've been trying to learn as much as I can. I've gotten the price lists, I've gotten some of the sales literature describing what these things are and who's buying them. I've struck out with a lot of the law enforcement people, but where I got some really interesting stuff was through the FCC. So it's important to note that because these devices broadcast as cell towers, and because they're using the same spectrum that the cell phone companies have paid for, and paid for it's extremely expensive spectrum that is auctioned off by the FCC, it's not entirely clear whether you can just set one of these things up and use it. And I know that Alan will talk about this a little bit more. When I filed a FOIA with the FCC, I found out that local and state law enforcement agencies actually request permission of the FCC before they use these things. Every local law enforcement agency that I found that has requested permission to use these things all had the exact same text in their letters, which suggests that it was probably provided by Harris as like the process of issuing these things. And so the FCC is playing a role. The FCC knows that this technology exists, and they license the Harris device. When Harris makes a new model, they submit it for FCC testing. The FCC is giving them some kind of like device ID to show that it doesn't unduly interfere with the communications network. And so the FCC knows what's going on. It's also, I think, really critical to understand that the Stingray, because it emulates a cell tower and tricks people's phones into talking to the gear, is essentially exploiting a security vulnerability in the cell phone system. And for those of you who aren't aware, there's a debate going on right now in Washington, largely via scholars, over whether there should be expanded law enforcement intercept capabilities for things like Skype or Gmail or other modern communication services. And there is a school of thought that suggests that, or that believes that new legally compelled interception backdoors are a bad thing. And so a group of scholars, including Matt Blaze, Susan Landau, and Steve Bellevin, have said it's better for the government to hack into people's equipment and people's computers than it is to force Google or Skype or Facebook to put in new intercept capabilities into their products. Well, if you think of the services that AT&T and Verizon provide when they provide a wiretap, a CALIA-required wiretap, if you think of that as a legally compelled backdoor, then the use of a Stingray is akin to the government hacking into your phone. They are taking advantage of the security vulnerability in the phone, or a flaw in the design of the phone system, which is that phones will respond to any tower that advertises itself as a tower of that person's phone carrier. And there's no way to really fix this. Even if you have the latest and greatest cell phone in your pocket, whether you have an iPhone 5 or the Google Galaxy Nexus, whatever, even if you have a 4G phone, your phone still talks 2G. Your phone is backward compatible because you may drive to West Virginia and go and see your family, or you may go camping. And so even though the 3G and 4G protocols are secure and have authentication and have encryption and have all these bells and whistles, what the government does is they jam 3G and 4G, and they force your phone to go back to this crappy, insecure 2G standard, and then suddenly your phone is talking to the government device. So it's important to understand that the government, through this technology, is in fact exploiting a vulnerability in the phone system. It's also important to understand that the government doesn't have a monopoly over the use of Stingray hardware, right? So if I'm Joe, the average citizen, and I call up AT&T and I say, I would really like it if you wiretapped Alan's phone, AT&T's lawyers would tell me to get lost, right? The government has a monopoly over lawful interception. Foreign governments cannot call up AT&T and say, we would really like it if you intercepted Alan's phone calls. They will also be told to get lost. But when it comes to exploiting security vulnerabilities in the phone system, anyone who wants to do it can do it. Even if it's illegal, effectively, anyone can do it. And so although the Stingrays and the similar devices were originally sold by Western surveillance companies in Germany, in the UK, and the US, there's now a global market for this stuff. And there are Israeli companies, and Spanish companies, and French companies, and Chinese, and Indian, and Russian, who sell it to basically anyone who shows up. And so what this means then is that our phones, individuals' phones, businesses' phones, the phones of government officials, are all vulnerable to the security flaws that the Stingray takes advantage of. The FCC knows about these flaws because they are licensing the Stingray, and they are permitting local law enforcement agencies to use the Stingray, and the FCC isn't doing anything to fix the vulnerabilities because they're sort of in on the scheme. The Stingray is just sort of one example of the balancing act that takes place when the government exploits security vulnerabilities. And this is just one example. But the Stingray problem is a big one because the cost of fixing this is so expensive. If the government takes advantage of a security flaw in Windows, Microsoft can push out a patch at a relatively low cost, and people are suddenly protected. When the government takes advantage of a security vulnerability in the phone system, patching every phone, patching every old phone is really expensive, and the phone companies don't want to do it, and in some cases you won't be able to patch many of the phones. So this is a flaw that is going to stick with us for a long, long time. The last thing I want to say about these devices is that over the last sort of year and a half, 2 years, I've called up several companies in the Beltway area who sell or resell these devices, and I call them up on the phone. I say, hi, my name is Chris Segoyan. I work for the ACLU. I'm calling about this device that you sell. I'm fascinated by it, blah, 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 blah. And I don't think they get many phone calls. Some of them are in Chantilly, Virginia. A bunch are also in Fayetteville, North Carolina, which is where Special Forces and Fort Bragg are. And so I've called these folks, and on multiple occasions, I've had 30 to 45-minute phone calls with people about this technology. They are quite happy to answer questions, but at the end of every phone call, they all let me know that they will have to notify the people at NSA about the telephone call, and if I want to talk to them again, NSA will have to approve it. I just think it's interesting to flag the fact that this is a technology that NSA seems to be coordinating the use of in some way, and NSA is definitely in communication with every vendor of this equipment. Oh, and the last thing I'll say is, although companies sell this around the world to governments, and although the Chinese government can buy this and the Indian government can buy this, there's also been this really interesting change in the last couple of years, which is you can now build one of these devices for about $1,000 using open source hardware. And in fact, people have demonstrated this at Black Hat and DEF CON. And in fact, last summer, I organized a demo for congressional staff, for staff working for 3 members of Congress, and we did a live demo of interception of voice and text messages in a House hearing room, and scared the bejesus out of the staff assembled. If you are comfortable with your own government using this, and you are comfortable with the risk of a foreign government using this, even because it means that our government can still keep using this against the bad guys, it may, even if those things are okay, it may be time to evaluate the status quo when any hacker or identity thief or private investigator can build one of these things and park it outside of a Silicon Valley office or a bank or a law firm and intercept calls. But the age of low-cost Stingrays is looming on the horizon, and I don't think law enforcement have fully woken up to what's coming soon. Thank you.
So with that in mind, Alan, why don't you tell us a little bit about the legal basis for these and the broader effect they have on privacy as well?
Sure. Let me see if
That can work.
Oh, you know what? Sorry, I forgot to say one thing. I forgot to say when you would use these. So let me just quickly say why you would use a Stingray. There are 3 main scenarios when you would use a Stingray. So the Rig Maiden case, as I mentioned this morning, the phone companies are required to provide location data through the location capabilities through the E911 law. Verizon and Sprint do this via GPS chip, and T-Mobile and AT&T do it through the towers. Verizon and Sprint only put the chips in phones because phones are the only devices that are required to be able to call the ambulance and the police. Verizon and Sprint don't put GPS chips in their data cards, the card you put in your laptop to connect to the internet over the cell network. And Daniel David Rig Maiden was using a prepaid Verizon data card to access the web, and the government wanted to locate him. They could not get an accurate ping of his phone because he was using a Verizon data card and Verizon didn't have a GPS chip. So the first reason you would do it is if the phone company is not capable of locating the device for some reason. The second reason you would do it is if you believe that your target is switching phones very frequently. So let's say your target is using burner disposable cell phones. You know where he lives, you know where he works, and you park the Stingray van outside his office and send the signals through his wall, and then you get the serial numbers of the devices inside. You're not looking to geolocate, you're not doing an intercept, although devices may be capable of doing an intercept. You just want the serial numbers of the phone so you can then go to the phone company and bring up a wiretap. In that case, a Stingray is going to be really, really useful. And then the third and most interesting scenario is when the phone company won't help you. So if you're doing a foreign intelligence surveillance effort, if you're spying on politicians in France and the French phone company won't help you out, a Stingray is really useful because you can drive it through the streets of Paris. The same goes for the streets of Washington, D.C. if you're the Chinese government. When you cannot get the phone company's assistance, the Stingray is the next best thing. All right, sorry about that.
No problem. I want to thank Chris and Margot and people at Yale for having me here. I'm going to talk a bit, as Jen mentioned, about the legal basis for the use of this technology, which, I think ties together some of what the other panelists have been talking about today. So the first panel, talked a lot about the Fourth Amendment and standards for location tracking. The second panel talked about statutory standards, and I think we're in an interesting space here with the use of these IMSI catchers and digital analyzer technologies where the legal standards are not clear. We know a bit of the standards that law enforcement believes applies. The DOJ has their own theories, and I think that it's interesting to unpack that a little bit. So if we start out with the Fourth Amendment interest that we spoke about this morning, two cases other than Jones, I think, have an impact on the use of this technology. And those two cases are United States versus Caro and Kylo versus United States. So these are both cases that involve involve technologies that can reveal details within protected spaces. Caro was one of the original sort of tracking beeper cases. But the unique thing about Caro was that the Supreme Court held in that case that when they used a beeper technology to reveal the location of a barrel basically within a home, and the fact that that barrel remained within the home, that was a Fourth Amendment search. And of course in Kylo, the Supreme Court ruled that the use of an advanced technology to reveal details, in that case heat, emanating from within a home, also constituted a search. So these are good cases to keep in mind when thinking about the use of this Stingray technology, when in fact it can be used and has been used in cases like Rig Maiden to locate individuals within their home. So then we think about what the statutory provisions that apply are. So there are statutory protections in place having to do with location. I just want to key on this quickly. We've talked about ECPA today and the standards for requesting disclosure. Of course, that's not evident in this case where you're not requesting records from a phone company, you're collecting them directly. So I just wanted to outline that there are protections specifically in the Communications Act highlighting location information as both consumer proprietary network information and limiting the collection of location information with a mere pen trap order. And this is where the hybrid theory that was discussed in the previous panel comes from. So the DOJ view has been, and as Chris mentioned, this technology has been used for over 15 years. Used to be referred to as a digital analyzer. The DOJ view was originally that they could get a pen register order to use these devices. A court ruled in 1995 that a pen register, that these devices did not fit within the statutory definition of a pen register, but the devices used at the time, which was only collecting call information, didn't require an order at all. And so it remained largely unregulated. So that changed when the Patriot Act amended the pen register statute. And now it's the DOJ's view that that these devices can constitute a pen register because they collect signal information. So you can see a bit of the language there of what was changed and why that matters. So that this is from the FOIA. This is a PowerPoint deck from a FOIA request that I'm pursuing for documents related to Stingray from the FBI. So it's the DOJ's view that this device fits under the pen register standard. But of course, as I just pointed out, the current communications law prohibits the collection of location information using a mere pen register order. And I think Judge Alsley will mention how the government is going about requesting these issues. And the other problem that comes up is the issue of interference. So the Communications Act also regulates devices that cause interference to communications services. The DOJ has noted, again, in their own documents about this technology, they've flagged this as a potential issue. This one provision of the Communications Act, 333, prohibits willful interference with a signal. As Chris mentioned, some law enforcement agencies are seeking essentially permission from the FCC. It's possible that this is at issue there. But I've also seen reference to the pen register statute in the sense that they're keying in on this language at the bottom about imposing a pen register with a minimum of interference. But this language does not actually mesh with the type of location triangulation that's actually going on with this technology. So the broader privacy implication here is similar to what Chris discussed earlier about tower dumps, that necessarily a Stingray is going to collect a broad range of information about nearby devices beyond just the target. So one of the questions that we have is, what happens to all that data? What happens to the data regarding innocent devices? As you can see, the FBI is not particularly forthcoming on their maintenance or purging of this data, but it's good to know that they at least are thinking about it. And this brings up another issue that Chris mentioned, which is the extreme control and secrecy that's being exerted over this technology and the use of this technology. As you can see, there are heavy redactions in the FOIA documents that I've received so far. And one thing that I think is particularly interesting is that these documents are being withheld under the National Security Act of 1947, which is strange given that I'm requesting these documents from the FBI, not from the NSA. So that's an issue that hasn't been completely ironed out yet, but as Chris pointed out, there's tie-ins back to the NSA for the use of this technology, and there's some level of sort of control going on there. And that sort of, you can see that in the documents themselves, because huge swaths of the pages that have been disclosed are withheld under this B3 statute, including, in this context, it's a conference that was held at some point for DOJ employees, and I can't even know the titles of the subject matter on the agenda in the conference. Introduction to blank, or just blank. And this is a very instructive page. So we're not getting a ton of information about how this technology is used, but as I mentioned, there are several interesting questions about the legal authority to use this technology under the statute, under the Fourth Amendment, and that's what I think we're really working to uncover here.
Thanks. So, Judge Owsley, what are you seeing actually in your courtroom when these are requested?
Well, I think just generally, and Judge Smith will probably back me up on this, it's not like we see a lot of these requests. To my knowledge, and I say to my knowledge because, well, to my knowledge, I've seen two in the last couple years. I may have seen them before and not realized what it was, because what they do is they present an application that looks essentially like a pen register application. So any magistrate judge that is typically looking at a lot of pen register applications and not paying enough attention to the details may be signing an application that is authorizing a Stingray. And at one point, I got my first one, and the first thing I did is I called up Judge Smith and said, "Hey, I got this. This is curious. What do you think about that?" He's like, "Oh, that's a triggerfish." What's a triggerfish? Well, it's this and that, and so it's a Stingray, triggerfish, cell site simulator, and so that's one of the things is you have all these terms for it, and in my experience, magistrate judges are not the most technologically savvy group of people, maybe more so than other judges, but not all that conversing in a lot of this technology. So I sent out, after a while, I got another request, and I sent out an email essentially to every magistrate judge in the country, explaining to them what a Stingray was and what a cell tower dump was. And I wanted information on what they were seeing on both of them. And I would probably get responses from, say, maybe 10% or so of the magistrate judges around the country, many of them saying, "That's interesting. I've never seen anything like that." And then a few people would have seen one or the other or both. So either somehow in Texas, it's very prevalent that you need Stingray requests and cell tower dumps, or there are magistrate judges around the country that are getting these requests, not realizing what these requests are, and authorizing them as a 2703D order or a pen register. So let me talk a little bit. And when I get these types of requests, Stingray, usually I have an agent in my office, and so the first thing I do is I start asking them questions, and they often don't understand what they're asking for either. And so I said, well, let's get the AUSA on the phone, or let's get the AUSA over here, and we can talk about it a little bit more. And so we do that, and typically the AUSA doesn't have any more insight or understanding of the technology or what they're fully requesting, because they're using basically a form that's been provided to them by Maine Justice, and they're just told to go forward and use that form. I'm just going to give you the two examples that I have, so you at least have an understanding of where they've attempted to use them in my experience, why, and give you a sense of sort of how they might be utilized. The first one I had was a request involving a prison. And there were allegations of criminal activity within a prison by inmates in which the government wanted to access, they basically wanted the Stingray to locate and track that phone and find out where it was and see what it was calling and whatnot. And I said, that's when I called Judge Smith, and we had a conversation. I had a conversation with some other people. And to the AUSA, I'm like, well, I need more information about this. I'm not sure, that this really fits into the pen register statute. So I'm told the AUSA will get back to me with a memo. So a week later, I call up the AUSA. I said, I'm still waiting for that memo. I have this open pen register application on my desk, and I hate to let these things lie around. Oh, I'm going to get it to you. And it goes on for about 6 weeks, and finally, the AUSA comes back and, well, Judge, a couple days after we filed that application, the prison officials located the phone. I said, well, okay, then you don't get an application because it's moot. And they went away. And then, so the second time I had one was a drug enforcement investigation, and they had a cell phone number of the target at one point, but he had changed phones to change his number, and so they weren't sure of what his number was, and they wanted to track him based on where he was living. Again, I asked him sort of for authority. It's not forthcoming. I asked him to explain to me what, if anything, they're going to do with the various other information that they get. Again, that's not forthcoming, and ultimately I issued a decision in part relying on some of the stuff that was mentioned about Rigmate and denied it. And so that's generally been my experience with Stingrays.
So in the boilerplate orders that you are being asked to hand down, you said they look like regular pen register orders, but usually those are referring to a third party. And so actually in the Rigmaiden case, one of those orders also was referring to Verizon to assist the government. But it seems to me that that's not actually what is happening. So what did those orders look like? And
to be honest, I haven't looked at one recently. But if you go onto the DOJ's website, or not website, if you search electronic surveillance manual, you can get, it's about, 250 page document. And if you search for the term triggerfish, it will come up with the request, and it uses the language from its pen register application, which I think just precedes it in the manual. And they also attach a proposed order to attach with the application. So it's not exactly like your garden variety pen register application, but they're citing 3123. They may label it as a pen register because their theory is they're seeking a phone number or what phone numbers are receiving, and so they're trying to pigeonhole it into that, and so.
I think the other thing to keep in mind there, if you look at, I think this is the right one. So one thing that they're doing at times is a pen register is usually directed at a third party, and one of the reasons is that the third party helps them implement the pen register. And that's not necessarily the case with the Stingray, because they can just use the device to capture information about nearby phones. But they do, I believe, at times they can use the service provider to help them facilitate that process by first narrowing the scope of where they're looking. So it's possible that in that example that Verizon would give them cell site information first to narrow the range of where they're going to go with the van. And then once they have that information, they take the van out to that area, turn on the Stingray, and then they can find the target device.
So the DOJ now says that these are pen registers. I'm going to guess that you guys disagree, but what do you think the order should be? Or do you think that pen register is valid? I guess it's theoretically possible that you've completely changed your mind in the last
20 minutes.
20 minutes, yeah.
I mean, so the ACLU and EFF filed an amicus brief in Rig Baden's case. And one of the issues that we raised in our brief was that these devices and the use of these devices is very similar to a general warrant, right? The thing that our founding fathers fought against and opposed the use of by the British, right? In the scenario where the government doesn't know who they're looking for, they know the telephone number, but they don't know where the person is, or they know the phone serial number, but they don't know where they are. And the government's driving around a neighborhood with like an unmarked van, driving around trying to narrow down and find out which house a particular device is in. They're sending signals through people's walls. They're sending signals through the walls of a lot of innocent people. None of those people are the suspects of a crime. None of those people will ever be told. It's not really that different than the police knocking on every door and walking into everyone's living room to see if there's someone hiding behind the sofa, except that here the government has a device that does it for them. I would argue that, and I'm not a lawyer, and this is not the ACLU official position yet. I would hope at some point we would be able to argue that, in fact, when you're using a Stingray to find someone where you're going to be looking through a lot of innocent people's houses, that in fact a search warrant isn't enough either. I just don't think it's kosher for the government to be searching the homes of 50 or 100 or 200 innocent people to try and find the one guy who's hiding somewhere. Now, if they know where the target is and they are just trying to find out which cell phone he's using that day, so the sort of drug dealer burner scenario, I think in that case a warrant should be the right standard. They're sending signals through your walls. I think it's very similar to the spike mic cases that we saw a few decades ago. I mean, these signals go through the wall of your house, through your car, through your purse, through your pocketbook, through your jeans. I mean, wherever your phone is, the signals are going all the way through. This is different than Kylo, because in Kylo you had these thermal signals emanating from the house. Here, the government's signals are going through your wall. So I think at the very least we're looking at a warrant, but I think there are some real situations where they shouldn't be using these things at all.
I think that one of the problems with the pen register theory is the provision that I talked about earlier of CALEA that limits the collection of location information with a mere pen register. And this is a problem that's solved theoretically in the historical and prospective tracking context, as the earlier panel discussed, with the hybrid order. But since we're not talking about stored communications, the hybrid order doesn't make any sense in this context, even if it made sense in the other context. So I think it's very problematic to say that they can use a pen register order to authorize Stingray surveillance that collects location information. And then in addition, I generally agree with what Chris was saying about this penetrating the walls of homes, closed containers. I think in general between Caro and Kylo and now Jones with the trespass theory is a pretty clear view that this is a Fourth Amendment search, and I think that in general that requires a warrant standard, and it's even more problematic when you talk about the impact on private users, non-target users, and whether the solution is minimization or not using the technology at all is I think an interesting conversation, but it requires us to know, I think, a lot more about the technology and to have a bit more transparency about what's going on.
I just wanted to follow up on the pen register, the statute. I think historically the way the statute is designed and drafted and the way it's been interpreted by courts is that you need to have a target number. So it sort of flips it The Stingray sort of flips it on its head in the sense that you're really looking for the target number without instead of knowing what the target number is getting and then gathering the information that Congress anticipated in its pen register applications. And I don't know the answer to this in the Stingray context, but I see there's a fair amount of overlap for cell tower dumps and Stingrays. I think Stingrays is sort of cell tower dumps on steroids is I guess on some level how I view it, because you have actually with a pen register, you have a lesser standard for the government to go out and do its own surveillance, as opposed to, at least with the way that they're trying to do cell tower dumps. Now you have a higher standard in 2703D, and you actually have to go through the phone company. But I've seen in cell tower dump cases, there's a case out of Connecticut where they convicted someone where they got 180 cell phone numbers. Now, 179 of those were folks who had nothing to do with the crime, and if you want to look on Google and search it, you can find all those cell phone numbers. They are posted on the internet. There was a case out of Arizona involving, to me, the classic scenario, and Chris alluded to this earlier today about how you use a cell tower dump, at least efficiently from law enforcement perspective, in the sense of there was a series of bank robberies in Arizona, and they targeted 4 of the banks in rural areas, and I think they got over 150,000 different hits. So, and it's unclear to me if that's 150,000 different individuals or different utilizations of a cell phone. But you can see that, you know, there's a lot of compromise of that type of data, and I don't think the government sort of, one, appreciates that or has any plan for what they're going to do with it.
So one of the things we actually haven't really touched on is the capability of Stingrays and MC catchers to actually gather content. Is that something that any of you have heard about? And, you know, is that a concern for you at this point?
The Stingray device, or the MC catcher, the generic technology, can intercept content. I know this because I saw it with my own eyes in a congressional hearing room last summer. Harris, the company that makes the name brand Stingray product, doesn't have a lot of marketing material that's shown up online. In fact, I got my first ever glimpse at a bunch of material last week in Portuguese that I downloaded from a Brazilian surveillance vendor that happened to have something floating around. I've not seen any English language documentation for many of Harris's products. We do know from Harris's price list, the price list made available through the GSA, that they do sell an interception module for the Stingray product line. We don't know which agencies have purchased that interception module. However, for the other big MC catcher vendors, the Boeings, the Selections, and then all of these Israeli and Russian and Swiss and German companies, all of them advertise in big bold letters in their marketing material, interception of communications content. Not only do they do interception, so the classic scenario they describe in their sales literature is a hostage situation. You have a hostage crisis going on, the government parks outside, you know, the bank or whatever, turns on their fake cell tower, and when the hostage takers call, you know, a taxi company, it reroutes the call to the police taxi company, and they're like, sure, we'll be right there, and then they send the fake taxi to come pick them up. So with these commercial products, as advertised by foreign surveillance vendors, they can reroute calls, they can block calls. You see them being used right now in prisons in the US and abroad to only allow whitelisted phone numbers, so the prison guards can make all the calls they want, but anyone who's smuggled a phone into the prison is basically blacklisted. These devices can capture content, and Harris's previous family of products, the triggerfish, these analog. So the difference between the triggerfish and the Stingray is the triggerfish did analog cell phones and the Stingray did digital phones. That's my understanding. And the triggerfish line, more marketing material for those is available online, and those definitely advertise that they could capture content. I mean, I think they are capable. Whether the DEA or whether Joe Arpaio in Arizona has purchased the content interception kit is a matter for debate, but the technology is definitely capable of doing it.
And I think one thing to note is that in the DOJ documents that I've received so far, there are, I should have added to the slide as well, but there's definitely a number of pages where, at the top of a big slideshow for training materials, it says, "Thou shalt not intercept content," right? They're aware of this problem, but that in and of itself implies that the capability exists. And when you see discussions in email chains about internal discussions about the use and training of materials for this, you see references to one person to another saying, "Oh, do you understand how to turn the knobs?" Right? And so there's an implication that for some of these items, there may be the capability. They're maybe explicitly told not to do that under certain circumstances and under certain legal authority. But if the capability exists, and as this technology is loaned out to local law enforcement and on down the chain, is everyone going to be trained the same way? Is everyone going to be aware of the legal limitations of what they can do? If the capability exists, then I think there's always a possibility.
So I realize you've only had a couple of these come before your court, but, is this something that is mentioned? Do you think judges
They don't
are
understand
aware
the
of this?
technology,
Yeah.
but they know that they're supposed to say, we're not going for communications.
Okay.
I mean, so there is sort of this party line, at least at this point in time, of this is surveillance, but it's not surveillance for communications. So in the two cases that I've had, they at least understand that that's what they're supposed to say. They may not understand why they're saying it or anything else about the equipment, but they understand that is, a concern from Maine justice, and so they're concerned about it.
So do you think there's an understanding that this equipment is also gathering numbers of, innocent devices?
Well, I mean, I don't know. I haven't seen any literature from DOJ, and I haven't heard anything from their assistant United States attorneys that I've dealt with. I will say that I think the agents don't necessarily get the message that DOJ assistant United States attorneys get. So, when you talk to the agents, they're like, "Oh, we're just going to drive around. We're gonna follow this guy, and then he's going to go over to a club, and we're going to turn it on over there, and we're going to see, and then we're going to follow him here. He's going to go eat." And so there's a lot of that sort of. They understand how to surveil, but they don't understand the implications of what they're utilizing, and they may not appreciate the distinction between communication, no communication. I don't know if there's just a button that you hit or something like that, and all of a sudden you hear everything or not. But there's always that temptation to see what's going on.
I also think one thing Chris mentioned that I would underscore as well is I've seen in descriptions for local law enforcement applications for this technology mention of the denial, the sort of blocking functionality. And that gets into a whole host of other issues, as I mentioned, the interference problem, and just a question of what legal authority is required to deny service to someone's phone, right? As it's not exactly a search, but it's certainly something that I would imagine law enforcement can't just do whenever they please. They have to have some level of authority, and a pen register trap and trace doesn't really seem to fit that at all. So
there was one other point I wanted to emphasize, which is, so I've been filing FOIAs the last couple of years about this stuff, and I got a really interesting set of documents from ICE, Immigration and Customs Enforcement, a few months back, revealing that ICE has purchased $3 million worth of Stingrays over the last few years. And this was in the context of a request to buy more stuff, and they said, we should be able to buy the Stingray brand products because we've already spent $3 million on this stuff, and we don't want to switch to a different brand. At the time, they were also purchasing the airborne mounting kit for the Stingray, so airborne mounting kit and airborne training, so they were putting these things on airplanes, whether those were drones or manned planes, we don't know. ICE has $3 million worth of these things, and they're $60,000 a pop, so they've got a couple. The FBI has them, the DEA has them, the U.S. Marshals have them, local and state law enforcement agencies have them. There are a bunch of these things floating around, right? The police in Minnesota, in Texas, in Florida, in California, in LA they have them. So they're being used around the country by local, state, and federal law enforcement agencies, yet we have one opinion in 1995 saying that these things are kosher without any kind of order, And then last year, we get the first order from a magistrate judge saying, no, I'm not going to allow the use of this thing without a warrant. It's strange that there are so many of these things that when Alan files a FOIA, the FBI tells him that they have 20,000 documents that's going to take 2.5 years to deliver. They have 20,000 documents covering the use of this technology, and we have 2 orders, 2 or 3, maybe I think there's maybe 2 other cases we found was like a mention here and there. It's really strange that this device is being used in so many places by so many law enforcement agencies, yet so little stuff has surfaced. And I think that demonstrates an intentional act by law enforcement agencies to suppress discussion of the existence of this technology, how it works, or that it's being used at all.
So how is it that they've successfully been able to do this if they're supposedly using them so much?
I mean, I think if you want to be optimistic, you can say that they've forgotten to be as open as they could be in describing this. One other way would be to say that they're hiding the ball. But in Rigmaiden's case, for example, he had to go through 2 or 3 court-appointed lawyers, and then finally fired them all and did it himself before he was able to catch them. He was able to find sufficient information to show that they were using this, and even for a while, the government was saying they weren't using this. They were saying, oh, we were merely passively collecting data. We weren't sending out any signals. Now, maybe that's because this is so technical that the folks who are writing the briefs don't know what's going on, or maybe they just really, really don't want anyone to know what's happening. But there really isn't much discussion of this, and there's a lot less than you would expect given how many people have this device.
I think one answer also is that, again, from the documents, it's clear that Justice has a pretty strong belief, and this came up in the Rigmaiden case as well, that this is a law enforcement sensitive method, and it's their belief that it's privileged, and they will actively, and they did in the Rigmaiden case, and they have in at least one other case, United States versus Gary, suppressed information about the technique in discovery in a criminal case. And so it's really hard to build case law around the use of this technique when they refuse to disclose anything about the technique, even in a criminal case where they're bringing evidence that was gathered using that technique.
But it's not just law enforcement, right? This is national security as well.
Right.
And I think the fact that NSA is involved in some way in this, and the fact that they're using similar technology, if not the same technology, in war zones, in Iraq, in Afghanistan. These things are likely mounted on drones. There's a significant national security aspect to this technology, and I think you end up with a weird situation when you have small-town sheriffs and intelligence agencies using the same gear, right? And it's much easier to keep a secret when it's just the spooks. But when you have small-town cops using this stuff and people being prosecuted using evidence that's derived from this gear, it becomes very difficult to keep everything under wraps.
Yep.
So is this, the evidence that they get from these, does it appear in any cases? I mean, how is this not something that is, used later on?
Yeah, I mean, as I mentioned, in the Rigmaiden case, it came up in at least one other case, again, criminal case. They briefed this law enforcement sensitive technique issue. And I think they being Justice takes the position that even in criminal cases where they have evidence derived from this technique, they don't want to reveal the existence of the technique or the fact that they used this technique because they consider it to be sensitive and privileged. And the problem there is, as we discussed earlier today, we know there's a long history and information available about wiretaps, and we know a lot about at least how historical cell records are collected and prospective cell record requests occur. And we know comparatively very little about how this technology is used by law enforcement, and it makes it very hard to evaluate, the equities and the statutory and constitutional standards that apply to the use of this technology when it is basically in a black box.
Well, and that burden would fall on criminal defense attorneys. I mean, and they're, federal public defender, very taxed, or even, the criminal defense attorneys in general. So they get their discovery package, and then, you know, they go forward from there, and they may not even think to question how the number was obtained or whatever was obtained through the Stingray. They just sort of go forward, and if it doesn't scream out to them as a sort of standard sort of motion to suppress issue, then they go on, and, you know, they look at the other issues that they may or may not have for their client's defense.
I mean, I think it's also important to remember here, the government still hasn't even conceded that they were using a Stingray in Rigmaden's case. They say that the Stingray is a generic term used by officers. They won't even confirm that it was the Harris Stingray device that was used in this case. Right? I mean, they say that the officers who used those words in the documents that Rigmaden obtained didn't really know what was going on. They weren't the ones using the technology, and so, you know, they've conceded that they used some equipment that transmitted signals, but they won't even say which particular equipment it was or what kind of signals were sent.
So I have one last question, and then we'll open it up to the room. But are you more concerned about Stingrays or cell tower dumps? Because, you know, Judge Owsley mentioned that, you know, these are like cell tower dumps on steroids, but I do feel like you have to have an officer who's driving around or flying around or whatever. So it's a little bit more like the beeper scenario than just getting all the cell towers in your city.
All right, so I want to emphasize this is my personal view because we haven't figured this out internally yet. I am most bothered by direct acquisition of surveillance by the government. Whatever role the phone company lawyers play, they are perhaps some form of speed bump. And we can argue about how effective of a speed bump they are and if they've been thoroughly captured or just slightly captured by law enforcement. But they have some form of resistance. There are instances where the phone company lawyers say, you know what, that's not going to work. We need a higher order, or maybe we'll tell the person, or we'll invite amicus briefs from outsiders. That's not possible when the government goes out and drives around the neighborhood and sends signals, invisible signals through your wall. It's also not possible when the government hacks into your cell phone. And my personal view is that direct acquisition or direct surveillance by the government is way more prone to abuse and is way more likely to remain secret forever. I am deeply bothered by secret surveillance techniques that are not reviewed by an independent third party, and given that the government doesn't seem to be too inclined to be very open with magistrates about what's happening, Stingrays and other technologies that exploit security flaws give me the heebie-jeebies.
Yeah, I mean, I think the biggest problem I see with Stingrays is the secrecy aspect, the fact that we don't know how they're used, how exactly they work, what different, you know, techniques are available, capabilities are there, and keyed in with the point Chris is making that, you know, the accountability measures that would be in place for other, you know, warranted, more standard surveillance methods are really non-existent here. I think, you know, tower dumps can also collect a lot of information about innocent non-target devices, but with Stingrays, it's mobile, right? They can move around and thus gather even more information about devices. It's just not clear what limitations are in place. And I think there's similar problems with the techniques, but I think that's the biggest issue with Stingrays.
I generally concur, although, you know, my concern generally is just for the third-party information. I think probably volume-wise you get, and Chris would tell me if I'm wrong, you probably have a chance to get more on a cell tower dump because you're talking more towers and as opposed to one apparatus that's going around on a sort of micro level. But if you're the individual whose information's sort of swept up, I don't think it matters whether it's through a cell tower dump or a Stingray.
I mean, in either case, you're not going to know.
Right. Unless it's posted on the internet, which is not possible, I guess.
So are there any questions? Yeah, just go up to the microphone on either end.
Hi, Jim Green. I have two questions about just the nature of how the tool is used, if we know this yet. The first goes to the applications that are made to the FCC and just what the nature of those are, and particularly where they're directed, because if they go to say, the Office of Engineering and Technology, then it would probably suggest that it's an interference analysis versus if they go to the Office of General Counsel. And the other one is, do the more muscular stingrays that law enforcement uses and intelligence agencies use have the ability to dial into a specific IMEI or other unique identifier such that even if they can passively receive an enormous amount of information from discrete cell phones, the government could claim when we're passing signals through walls, we're looking for one specific phone and we're not really pinging everything.
So that's a complex question. I'd need to look, for the first one, I'd need to look at the letters that I got back. So I got these letters from local law enforcement agencies to the FCC asking for permission. I need to go and see, I think it was the General Counsel's office. Interestingly enough, I also found through Google searching a single request from a company in Fayetteville, North Carolina, requesting permission to use a Stingray, the Boeing device, and then a couple other similar ones. When I called the CEO of the company, who answered the phone, he told me that they wanted to train special forces in how to use the gear, and so they figured it was probably a good idea to get permission from the FCC, and the license was granted. And the guy who I spoke with said, you know, we're not the only ones doing training. We are the only ones who've applied for a license, but there are others who are purchasing these devices and using it for training and who aren't bothering to get licenses. In terms of how the devices work and whether they can send signals into a house that will only the particular phone in question will respond to, my understanding of how they work is that generally the tower sort of sends out a signal to everything in the area that says, hi, I'm an AT&T tower and I'm nearby. And then any AT&T phones in the area will respond and say, hi, I'm an AT&T phone, this is my serial number and I'm here. And so there's no way to send a signal into a house that says, if you are this serial number, please respond, everyone else don't bother responding. Just the way the protocol is designed, I think every device naturally responds. I don't think there's a way to do like a Go Fish, but a specific Go Fish for one phone.
Hi, I just have one small breadcrumb to contribute to this, which is that I was recently at a party, and there was an FBI agent at the party, and I said, so tell me
Great
about...
party.
Yeah, I know. And so making small talk, I said, so tell me about this Stingray stuff. And he explained to me that it was his field office's policy to only use Stingrays to locate fugitives, because that way there was never the possibility that there would be a suppression motion filed.
You still get third-party information, though. But yeah, I mean, I was talking to someone about this. It's a probable cause standard to sign the stuff for fugitives, whether it's, you know, whatever the electronic surveillance is. But you can't come in as a fugitive that's been caught and say, I was wrongly surveilled and caught, I get a get out of jail free card. So like the agent said, I mean, it's sort of it's not going anywhere, even if it's not up to the proper standard.
And one other point about the fugitive issue is there's an older FOIA document that I think generated one of the first news stories about triggerfish technology from, I believe it was 2007 or 2008, where within a different FOIA request, EFF received an email chain where a FBI field agent and tech officer was sort of complaining about the practice of the fugitive tracking groups and how they would come to the sort of tech agents requesting the use of the van, what they refer to as the WIT van, because that's the group that sort of operates the van, and saying, well, these guys basically want to take the van and drive it all around town, aimlessly looking for these people. When we ask them questions, you know, do you know where this person lives? Do you know what areas they frequent? Have you done background research to figure out where they might be so we can narrow the scope of this? They get blank stares. So.
Hi, Alex Abdo from the ACLU. Just a quick question. I'm not an expert in the pen register statute, so forgive me if this is the answer to this question is obvious. But and this is perhaps to you, Judge Owsley, do judges have discretion when issuing pen register or orders to essentially impose minimization requirements on the extra information that Stingray acquisitions might acquire? And are you aware of any judges imposing those types of restrictions? And perhaps you too, Judge Smith, if you know.
I don't think they have it because really a pen register is almost essentially a ministerial act. So there's very little discretion for a magistrate judge in a true pen register. Now, if you bring a wolf and you put sheep's clothing over it and you tell me it's a sheep and I realize that it's a wolf, I'm not going to say, oh, well, you can put that sheep with the others. I'm going to say no. So in that case, I think a magistrate judge is well within her or his position and authority to say this is not really a pen register and you can't have this based on this standard because it's an extremely low standard.
That's a good segue into my question, which is it would seem that pen registers can't be used for this considering the prescription in CALEA against relying solely on a pen register for call location information. So why aren't they at least using hybrid orders? It's my first small question. Bigger comment question, first off, thanks for the great panel. This issue raises a sort of more fundamental, almost philosophical issue that was at the heart of the NSA case and sort of the substance issue that we may never get to, which is what counts as an interception? And what we've always argued in the NSA cases, or rather EFF, where I used to work, and they're still arguing it now, is that as soon as a communication goes into a device controlled by the government, that is an interception and that is a seizure of that communication. Paul Ohm wrote a great short piece on this called The Right to Delete, where as soon as you've been dispossessed of the right to dispose of your communication, that's when, that's the Fourth Amendment moment. Correct me if I'm wrong, but my understanding of the IMSI catcher is that regardless of whether, as Judge Owsley says, they flip a switch and convert it to audio that you can listen to, or whether or not they store the communication, all the call content in the area is going through that IMSI catcher. Am I right? Is that correct? I mean, isn't it like a man in the middle such that all the content is going through the device?
So the answer to Kevin's question is complex. So why don't you respond to the first part? You want to pass?
No.
All right, then let me
Go ahead.
Let me respond. All right, so the way that if you're using a Stingray just to gather the serial numbers of the devices nearby, it's sort of it's a tower that breaks the rules. So the tower broadcasts and says, "Hi, I'm an AT&T tower. I'm available, and I have a really strong signal strength." And by the way, the phone doesn't detect the signal strength of the tower broadcasts its own signal strength as a value. And so the government's tower is like, I have a signal strength of 1 million. And AT&T's tower strength is like 50,000, and so the government's tower always wins. This is actually one of the features that the British company patented, this like lying about your signal strength. The government tower says, I'm an AT&T tower, I'm available, come use me. And then your phone's like, oh, cool, I'm an AT&T phone, please provide me with service. And then the government's tower, once it has your serial number, says, actually, I changed my mind, I don't want to provide you service. Okay. So they get your serial, they can triangulate your location because there's been a back and forth, there's been some communication, but they don't actually have to carry your service. And they can do that really quickly without causing any drop in coverage or even any change in display on the phone. The commercial IMSI catchers I've seen usually have some kind of upper limit of the number of devices that they can perform a man-in-the-middle attack on simultaneously, and it's somewhere in the ballpark of 5 to 10. So I'm not aware of any IMSI catchers that can do like 500 phones simultaneous interception, but they do all seem to advertise the ability to like canvas an area and get hundreds of serial numbers in a relatively short period of time.
What about the phones that they're doing full pen registers on?
So you mean
I mean,
where they're
if
passively
log who you're talking to, is the content of that call going?
If they're doing a pen register so sorry for those of you who this is way too complex for, but there are two ways to perform interception. There's active interception and passive surveillance. Active means the tower is actually pretending to be a phone tower. It's like it's sending out signals, and then there's also passive surveillance where it just like sniffs the signals. Depending on the quality of the encryption used by the network, they may be able to just passively monitor stuff and get the pen register without sending any signals out. Whether that is a true interception or pen register, I mean, every signal is going through their device. They're just not looking at the parts that have the communication, sort of like a TCP dump on your computer. sorry, this is way too complex. It's complicated.
As to the first question, I think it's a little hard to parse because in the manuals or the training materials that I've seen, they discuss both cell site simulator technology and more traditional location tracking methods like historical records and real-time records. But they do have a point in there where they make the point that under the pen register statute and CLIA, as you mentioned, you can't gather location information. They indicate that a hybrid order is a thing that they know about. A lot of it's redacted, but it's not clear whether they're using those hybrid orders for Stingrays. And to me, the problem with that would be that there's no stored communications in a traditional sense that you're accessing from a provider. So I don't think it's a good fit for them. But
I pretty much agree with that. I mean, I don't know that I have much to add.
I don't know if we're out of time.
Yeah, just for.
Okay, so
we've got a
I
couple
just
more
wanted to
questions.
highlight something that Chris had said in light of what Susan instructed us on this morning on the impact of the exclusionary rule, which is that as part of its systematic efforts to reconstruct the silver platter doctrine, the court in Lopez Mendoza told us that the exclusionary rule doesn't apply in immigration contexts because the threat of exclusion in a criminal trial is sufficient to deter law enforcement officers. But the Fourth Circuit, in a case called Oscar Torres, which is 18 months ago or so, held that it also doesn't apply in criminal context if the primary motive of law enforcement is immigration enforcement, which is sort of a silver platter doctrine upon a silver platter doctrine, which suggests that if ICE is using this technology, it's entirely beyond court review because there is no remedy available if the Fourth Circuit is right. But separately, I wanted to ask Chris if he could comment on a related technology that I don't quite understand, but I think is similar to a Stingray, which is a technology that intercepts MAC addresses that are communicating with open, public wireless access points. And that's an important tool, I understand, for child exploitation and pornography prosecutions. And I just wanted to know whether it raises some of the similar issues that you've discussed with Stingrays.
So the difference is that Stingrays cost 60 grand, and even the tools required to build one yourself are $1,000 and require a significant amount of geeky expertise. What you're describing, so the tools that you would use to find, to sniff the network and find a particular MAC address on the Wi-Fi network, that software is built into every laptop. I mean, every laptop can do wireless sniffing. And it's built into Mac OS. The program, if you have a Mac laptop, is called TCP dump. You can run it on your own network lawfully, but not on anyone else's, as long as you're the only one on your network. I think it's difficult to compare those two things for the simple reason that wireless sniffing is taught in Computer Science 101, and everyone has the tools available, and you can readily encrypt your communications to at least stop people from intercepting the communications content, and you can change your MAC address at will, also with a command that's built into your laptop. You cannot change your phone's equivalent identifier easily, and in fact, some people have said that it should be illegal. That some phone companies have told the FCC they believe it is already illegal. And the tools to do interception are still not quite as easy as they are in the wireless space. So they're not the same.
So I think, do we have time for one more?
Since you're here partly in your role as principal technologist, I will ask you one other tech question. Chris, are there potential or actual tools being used? Are there sort of tech hackers and coders at work on ways of learning more about stingrays by observing them in the wild, as opposed to trying to get FOIA disclosures or cold calling CEOs?
So this is one of my favorite areas of emerging research. So an IMSI catcher is the device that is the generic Stingray. For some reason, in Berlin, there's like this core group of cell phone hackers. For some reason, they're all in Berlin, and they do open source cell phone security research. So those guys have built an IMSI catcher that detects the presence of an IMSI catcher nearby. And they've built them using a $20 prepaid phone that they've modified. The same phone that TrackPhone, the prepaid phone company, sells at 7-Eleven. They've modified this phone and used it to detect. So it turns out that even though a Stingray looks like a normal tower, it doesn't actually act like a normal tower. And if you know what you're looking for, it's so not like a regular tower, except that your phone isn't programmed to shout, hey, there's a Stingray nearby, run away. But so they've built some sophisticated software that looks for the signatures of a Stingray and then gives you different level of color warnings. So like green, yellow, and then red, run away, drop your phone and scream. So the IMSI catcher stuff is really interesting. A bit of unfortunate news. So there's this process called WASSNR, which is this international arms control agreement or arms traffic or export control agreement. And the latest round of WASSNR negotiations includes expansions that would both prohibit the export of IMSI catchers, but also prohibit the export of technology to catch IMSI catchers. And I think that is really, really problematic. So basically what they're saying is they want to limit the ability of certain governments to have ready access to things that could detect U.S. surveillance equipment or British surveillance equipment.
And it's not clear that using an IMSI catcher is kosher with the FCC, right?
I mean, you're passively monitoring highly regulated spectrum.
Right.
So probably not.
So, yeah.